Hello all, I am Teresa Manning, the director of the Title IX project at the National Association of Scholars. Thank you for joining us for this panel discussion regarding the administration of Title IX on campus, called The Good, the Bad, and the Ugly. Few issues have been as divisive as Title IX administration on campus. Students, parents, civil rights organizations, faculty, and administrators often complain that Title IX does not go far enough on the one hand, or that campuses and agencies are engaged in administrative overreach on the other. So this panel discussion is designed to ground listeners into the issues besetting Title IX. We would like to know, what is Title IX? How did it come to govern campus sexual harassment? And what do the new regulations released by the Department of Education mean for Title IX administrators and students, both the accused and the accusers of Title IX violations? Our panelists today are first Samantha Harris, a senior fellow at the Foundation for Individual Rights in Education, also known as FIRE, F-I-R-E, and now of counsel for Mudrick and Zucker, where she plans to represent those accused of Title IX violations. We also have Casey Johnson, a professor of history at the City University of New York Graduate Center and Brooklyn College. And lastly, Professor Nicholas Wolfinger, a professor of family and consumer studies and an adjunct professor of sociology at the University of Utah. Thank you, panelists, for all being here. The flexible structure that I am recommending is to start first with a bit of history and an explanation of what Title IX is. Second, where Title IX stands now, especially with respect to lawsuits filed. And third, a description of how perhaps a typical campus Title IX proceeding might work by one who has actually experienced it. So we'll start with Samantha, then Casey, and then Nicholas. So Samantha, I'm going to hand it over to you now to start with the history and background of Title IX.
Great, thank you. First of all, thank you for having me, and it's nice to see, I see a lot of familiar, I would like to say familiar faces, but familiar names on the attendee list. So nice to see all of you, and thanks everyone for joining us. You know, one of the first things that people ask when I talk about campus sexual misconduct and the unfair proceedings that so many students and faculty are subjected to is, well, why are colleges adjudicating these things? I mean, isn't rape a matter for the police? And you know, campuses aren't adjudicating murder cases, so what's happening? And you know, the answer, and that's not going to surprise anyone on this panel, is Title IX. You know, Title IX is the federal law that prohibits sex discrimination in federally funded educational institutions. And, you know, there is a jump between sex discrimination. I mean, if you look at the text of Title IX itself, it's very brief. It's just a few lines. And it says that you can't, you know, if you receive any sort of federal funding, you can't engage in discrimination based on sex. So how did we get from no discrimination based on sex to schools running, you know, these parallel justice systems where they're adjudicating claims of sexual misconduct? The answer is that over the years, Title IX is from 1972, and over the years since the law was passed, both courts and the Department of Education have expanded the scope of Title IX, first to include harassment by professors, and ultimately to include an obligation on the part of schools to address peer-on-peer student harassment. So in 1977, for the first time, a federal district court in Connecticut held that under Title IX, schools could be liable not just for sort of overt sex discrimination, you know, discriminating in admissions, but also for failing to respond to allegations of harassment by faculty. And in this case, it was a quid pro quo sexual harassment, which is what people sort of conventionally think of when you say sexual harassment, you know, the kind of sleep with me if you want an A type of behavior. That was 1977. And then throughout the 1990s, the Office for Civil Rights, which is the agency within the Department of Education that's responsible for Title IX enforcement, OCR and the courts began to find that schools were also responsible for responding to instances of known harassment by students. And in 1997, OCR issued a sexual harassment guidance that conclusively established that schools are responsible for responding to known instances of peer sexual harassment. And what OCR had to say about that is that if students are being harassed by other students on the basis of their sex, and the school knows about that but doesn't do anything about it, they're allowing discrimination to permeate, they're allowing a hostile environment to permeate the educational environment, and that amounts to discrimination based on sex. Because if you can't go to class, for example, because the person next to you has been stalking you or harassing you on the basis of your sex, then the idea is that you're being subjected to a discriminatory environment, and the school is responsible if they know about that but don't do anything about it. And then in 1999, for the first time, the Supreme Court actually recognized a private cause of action by students who were subjected to hostile environment peer harassment when a school didn't respond. So that really enabled all of these students to begin bringing Title IX claims against institutions for allegedly failing to respond to sexual harassment. And sort of things continued apace for a while. I mean, there are suits from the 90s and the early 2000s by students alleging that they were denied a fair process in a campus disciplinary proceeding. And certainly from the beginning of FIRE's existence, we've heard from students in both sexual and non-sexual misconduct proceedings about some of the problems with campus disciplinary tribunals. But things really took a dramatic turn in 2011. And that was when, in response to a sort of groundswell of activism around this perception that schools weren't doing enough to address particularly physical sexual misconduct on campus, the Office for Civil Rights issued a Dear Colleague letter that really radically transformed the way colleges and universities handled claims of sexual misconduct. The Dear Colleague letter itself, which did not go through any sort of notice and comment process, which is going to come into play later because we're going to talk about notice and comment again when we discuss the regulations. But with no notice and comment, the Dear Colleague letter required schools to lower their standard of evidence to the lowest burden of proof in civil law, preponderance of the evidence. It required schools, if they offered a student an appeal from a guilty finding, to also offer complainants the opportunity to appeal from a finding of not responsible. And it strongly discouraged cross-examination. And when I say strongly discouraged, it said that parties should never be cross-examining one another directly, but because virtually all schools prohibit advisors from playing any sort of active role in the process, that effectively amounted to a ban on cross-examination, because schools didn't have systems where advisors could conduct the cross-examination. So if parties weren't able to do it themselves, then what that really effectively meant was no cross-examination. And at the same time, around the same time that the Dear Colleague letter was issued, the Office for Civil Rights also dramatically ramped up the number of schools that it was investigating for alleged Title IX violations. And schools are very desperate to avoid this type of investigation. They're long, they're costly, and they ultimately could result in a loss of federal funding. So schools began to go even above and beyond the requirements of the Dear Colleague letter and really just abandon a lot of critical procedural protections, in an effort to make it seem like they were really aggressively combating sexual assault. So although it wasn't required by the Dear Colleague letter, a lot of schools did away with hearings altogether in favor of what we call a single investigator model, where you have one person just acting as detective, prosecutor, judge, and jury. Schools, gave students very limited notice about what they were alleged to have done wrong, and very limited access to the evidence. Oftentimes, and I can say this, now that I've been at FIRE for 15 years, but I recently went into private practice and I've done a few of these hearings, and schools will ask students to respond to an investigative report and give them, a few hours to review pages and pages and pages of evidence in the case. They can't take pictures, they can't make copies. So it really, effectively, schools are requiring students and faculty to defend themselves against very serious accusations with one hand tied behind their back. They have policies and procedures that make it really difficult, if not impossible, to mount a meaningful defense. And so, as I know KC is going to talk about, this sparked just a wave of lawsuits by accused students who are alleging that they were denied a fair process. Another thing that was sort of happening around the same time is that schools have really been trying to redefine norms around sexual consent and around what it means to consent to sex. So, over the past 10 years, you've had an increasing number of schools adopt what are called affirmative consent policies, where instead of taking sort of a traditional no means no approach to consent, they now take a yes means yes approach to consent. So, whereas under a no means no standard, sex is, presumptively consensual unless there's evidence that it wasn't consensual, right? Like if under a no means no standard, all you know is that two individuals had sex, then that sex is presumptively consensual unless there's some evidence, and it doesn't necessarily have to be evidence of force. It could be evidence of coercion or of incapacitation, but the burden is to come forward with evidence that it wasn't consensual. Under a yes means yes standard, sort of if all you know is that sex happened, the default is more that the sex wasn't consensual unless there's evidence that it was. So when you handle a proceeding under an affirmative consent standard, you'll have the investigator asking the accused student, okay, well, how did you know that you had consent to put your arm around her? Okay, well then how did you know you had consent to move your hand to her thigh? How did you know? So it's really sort of atomized in this way where if a student can't sort of come forward with a convincing explanation of how they knew they had consent at each individual step of an encounter, they're going to be found responsible for non-consensual sex. So, layering this affirmative consent standard on top of all of these other procedural, these reductions in procedural protections really led to a situation, an untenable situation where students and faculty really had no way of demonstrating their innocence in these proceedings. So in 2017, the Department of Education under Betsy DeVos announced that it was rescinding the Dear Colleague letter. It acknowledged a lot of the due process problems and acknowledged that perhaps the pendulum had swung too far. And the department announced that it was going to be engaging in formal rulemaking, which means, unlike the Dear Colleague letter, notice and comment. So in November of 2018, the department issued its proposed regulations, which then went through, I believe it was a 90-day or maybe a 60-day comment period, where more than 120,000 public comments were received. And then for the next, several years, the department painstakingly went through all of that feedback. If you've seen that the new regulations that came out are 2,033 pages long, that's not because they're 2,033 pages of regulations. They're actually about 25 pages of regulations, and the rest is the Department of Education responding very thoughtfully and in great detail to all of the concerns that commenters made. And one can see, if one compares the proposed regulations that were released in November 2018 with the new regulations that came out in May, that the department was in fact responsive to a lot of concerns. And these new regulations contain a lot of critical procedural protections for accused students. They require meaningful notice, which means, no longer can you just send somebody a letter saying, well, you've been accused of conduct that violates the school's sexual misconduct policy. Please come to a meeting on such and such date. No, you have to tell them what conduct they are alleged to have engaged in that violated the policy. Schools have to provide both sides with meaningful access to the evidence, which means no more, okay, you have 2 hours to review these 90 pages of investigative materials and prepare your response. They require a live hearing with cross-examination in a higher educational setting, which is absolutely critical. I mean, I can say conclusively now, having done, both a proceeding that was a single investigator and a proceeding that did allow for cross-examination, that there's no comparison in terms of your ability to test the credibility of the parties and get at the truth of what happened in the case. And they also require that the trainings that be given to people who are going to be adjudicating these things not only be unbiased, but that they be made publicly available on schools' websites. And this is something KC has done a tremendous amount of work on exposing some of these training materials, but a lot of adjudicators and investigators currently are trained using materials that use sex stereotypes. 50% of male students report engaging in non-consensual sexual contact in their college, things like that. Things that you would never be able to give to a jury as a jury instruction because they're highly prejudicial. So the new regulations require not only that these trainings be impartial, but also that they be transparent so that there can be some public accountability. Now, of course, we can get into this a little later. I'm still worried, as I'm sure my fellow panelists are, that schools are just going to move the bad stuff into their oral presentations. And I think we need to worry about how we're going to control for that. But so that's kind of where we are today. And I know there's going to be a Q&A section, and there's going to be, I see there is a question here about the reasonable person standard, which we can get to a little bit later. I've already sort of run over my allotted time, so I want to let my fellow panelists have their say, and then we can hop into more of a discussion of the regs and of all of these issues.
Excellent. Thank you so much, Samantha. And just a note to Chance, if you're listening, that I do not see any questions popping up. So if there's a technical issue there with allowing me to see and then ask the questions, maybe you could try to attend to that. But we'll turn now to Casey Johnson.
Under chat. It came up under chat, not Q&A. If you look there.
Here you are.
Okay.
So everybody that's listening, you can ask questions by clicking on the Q&A button at the bottom of your screen, and we'll run through those towards the end of the call once everybody gets through their presentations.
Excellent. Okay, thanks, Chance. So Casey, if you could run us through at least some of the litigation that has taken place since the 2011 DCL to flesh out a little bit of the problems it really did create. And then if you'd like to add to any commentary on the new regulations, picking up where Samantha left off.
Sure. Thanks to everyone for chiming in here. So I wanted to start with just a few statistics. Since the Dear Colleague letter, which came down on April 4th, 2011, there have been 564 accused students who have filed either state or federal lawsuits against their institution. As of now, and the most recent of these decisions came down a little over 2 hours ago, there have been 177 university setbacks in this area, 161 university wins, and 114 settlements before the court made any decision on a substantive issue. And most of these settlements, which presumably led to an expungement of the student's record, were not made out of the goodness of the university's heart, but to avoid a possible judicial defeat down the road. So why do these lawsuits matter? Well, first of all, the sheer scope of the lawsuits are significant. Courts, for very good reasons, tend to be extremely reluctant to involve themselves in campus disciplinary matters. They correctly assume that the academics have a better sense of what constitutes appropriate discipline on their campuses than do federal courts. And so to have so many decisions come down against schools in such a relatively short amount of time, it's essentially built an entirely new body of law. For comparison purposes, the average was between 1 and 2 lawsuits per year in the 2 decades before the Dear Colleague letter. The second reason why I think these lawsuits are critical is that they expose the core unfairness of the Obama era system. Because campus disciplinary processes due to FERPA occur behind closed doors, there's no even campus media coverage of these proceedings. We generally don't know what's going on until it gets into a real court, and then the college has to defend what it's done. And I think that the lawsuits have exposed what is, to me, the underlying and most troubling premise of the Dear Colleague letter and the entire approach of the Obama administration to this issue, which is that the best, or at least the most efficient way to increase reporting of campus sexual assault is to design procedures in which an accuser will know going in that she will not be asked challenging questions about the version of events that she's portraying. And the courts have consistently pushed back on that fundamental unfairness. And then a last thing where I think the court decisions are important. In an ideal world, universities would have responded to this torrent of defeats, again, in both the federal and state judiciary, by changing their procedures to make them more fair to the accused, to recognize the core unfairness of this process. Instead, if anything, what we've seen is the reverse. Universities essentially defying federal court authority or designing procedures that seek to evade the spirit of court authority. I'll give just one example. The Sixth Circuit now requires at public universities a live hearing with cross-examination, and it mentions the importance of this to determine credibility. At Lake Superior State in Michigan, a public university, they interpreted this decision as not guaranteeing a right to a live hearing and a cross-examination. Instead, they've set up a procedure in which the Title IX coordinator, without opportunity for appeal, can unilaterally decide that the case does not solely come down to credibility. Solely was never mentioned in the court decision. And as a result of that decision, the Title IX coordinator can invalidate any hearing and just allow a single investigator model to go through. And I think it's because of this defiance of court decisions that it makes robust regulation from the education department to ensure fair procedures under Title IX all the more important. So with that as a preface, I wanted to just briefly talk about three, I think, big areas that have come up in these court decisions. The first, and Sam has mentioned this in her presentation, is a right to cross-examination. And I wanted to quote two passages from the decision, which again came down very late this morning in California, in a case that involved Matt Biermeister, who was the former kicker at USC, who was expelled in a case where his alleged victim told the USC Title IX office that Biermeister had done nothing wrong and that they had misinterpreted what she had originally said. This was a single investigator case, so there was no hearing, there was no cross-examination. And the court, which was a state appeals court in California, held today that a university must balance its desire to protect victims of sexual misconduct with an accused's needs to adequately defend himself or herself. And then later in the opinion, in a case such as this one, where a student faces a severe sanction and disciplinary proceeding, and the university's decision depends on witness credibility, the accused student must be afforded an in-person hearing in which he may cross-examine critical witnesses to ensure the adjudicator has the ability to observe the witness's demeanor and properly decide credibility. And this, I think to anyone who follows these cases should seem like an obvious conclusion, and yet the vast majority of colleges before this wave of litigation and now the regulations denied this opportunity. Now, the critical court in advancing this has been the Sixth Circuit, Michigan, Ohio, Tennessee, and Kentucky. First in a case out of the University of Cincinnati, decided in 2017, and then in a case called Doe versus Baum in 2018, which involved an allegation at the University of Michigan. Doe versus Cincinnati is one of these really interesting decisions. It's one of my favorite decisions in this area because even though the holding of Cincinnati is really very limited, Cincinnati was a case in which there were no witnesses. The two students had met on Tinder. The accuser said that she didn't consent. The accused student said that he did, that she did, that he had consent. They both gave these statements to an investigator. The investigator wrote up a report saying that she believed the accuser, and then she presented it to a disciplinary panel. At the panel, neither the accuser nor the investigator appeared, which created this just extraordinary passage in the hearing in which the panel chair asked the accused student if he had any questions of the investigative report. And the question is, of course, how could the report have answered if there was no one else in the room? And the Sixth Circuit said, you have to provide some opportunity for cross-examination. They didn't specify what it had to be, but the decision itself is filled with paeans to the idea of cross-examination's value to pursue the truth. And the critical line from it is that both the accused student and the university have a common interest in this regard through fair procedures to get at the truth. And that idea was then expanded in this 2018 ruling against the University of Michigan. And the backdrop of this is that Michigan had decided to respond to Cincinnati, and Cincinnati was binding precedent for the University of Michigan by ignoring Cincinnati. Cincinnati required there had to be a hearing with some form of cross-examination. Michigan instead used a single investigator model with no cross-examination at all. And in the oral argument in the case, Judge Julia Smith-Gibbons of the Sixth Circuit said that she couldn't get past the defiance, and this was the word that she used, of the university, both of the Constitution and of Sixth Circuit binding precedent. And so the court came down hard with a ruling that said that in any case involving credibility in the sexual misconduct area, schools must provide a live hearing, they must provide cross-examination, and the questions must come from either the accused student or his lawyer or advisor. And it was the principles of that decision, Doe versus Baum, that inform the regulations. The regulations provision on cross-examination says there has to be a hearing, and the questions must come not from the student, because victims advocates had said that questions from the students could be traumatic. And so the education department, correctly in my opinion, said, fine, we'll ensure that the questions will come from the advisors. But they rejected the idea that the adjudicators could be trusted to ask the questions themselves. Second area with regards to the court decisions is this issue of training, which again, Sam had mentioned. There have been a number of these decisions. Schools have been required since 2015 as a result of a regulation under the Clery Act to train all adjudicators in Title IX proceedings. And the way I think the best way to think of this is imagine a rape trial in criminal court, where before the trial began, the prosecutor got to spend 3 or 6 hours with the jury, giving the jury all kinds of material that would predispose them to believe the complainant in the case. And this would be a system in which not only would the defense lawyer not get to challenge this training material, but wouldn't even get to see the training material before the adjudicator, before the trial began. Title IX training is this bizarre area in which no school thus far has voluntarily made its training material public. This, of course, is going to change, but a number of decisions have made clear just how unfair the adjudication process is. And so, for instance, the decision against the University of Pennsylvania, which said that it was plausible that Penn had violated Title IX, discriminating against the accused male students' right to a proceeding free from gender discrimination, by training its adjudicators to believe that essentially any behavior was consistent with the accused student's guilt. It was a long proceeding of training material that was put together by a feminist law group that said that counterintuitive behavior equaled guilt. So people at Penn were trained that if an accuser is emotional, that's a sign of guilt. And if an accuser is taciturn, that's a sign of guilt. If an accuser is consistent in her presentations, that's a sign of guilt. If an accuser is inconsistent with her presentation, that's a sign of trauma and therefore a sign of guilt. There was essentially no way the accused student could win. The Penn training was mild compared to training used at the University of Mississippi, which also was the subject of a court win for an accused student. The Ole Miss training twice mentioned the possibility that Title IX panelists might encounter an accuser who lies during the proceeding. And the Ole Miss training trained the panelists to presume that when an accuser lies, that is a sign of her core truthfulness. And what she is attempting to do is to reconstruct the story in a way that would be convincing. This is, of course, it's madness. And the regulations attempt to deal with this in a Brandeisian fashion. The operating principle seems to be that sunlight is the best of disinfectants, and so it requires schools to place their training materials on their website. And I suspect what we will see is that the embarrassing and biased material now will be eliminated from these and probably, as Sam said, confined to verbal presentations. But anything that moves this towards blandness is I think, a victory, and it's a revelation of how important these court rulings have been. And then last in the court rulings, I think, has been a more overarching principle that sham hearings are simply unfair to the accused. And that's a phrase that comes from a Seventh Circuit opinion from Judge Barrett in a case called Doe versus Purdue University, where the accused student was lost his ROTC scholarship as a result of this decision. And this was a case in which the accuser not only didn't have to appear at the hearing and submit to cross-examination, she didn't even have to write a statement. Instead, a statement was written on her behalf by a campus victims advocate, who then presented that to the single investigator, who then accepted the statement on its face. The single investigator declined to speak to witnesses that the accused student said would be exculpatory. And at the hearing, there were two panelists who basically just accepted what the investigator said. And there are all kinds of provisions in the regulations that would make it very difficult for schools to sort of take this approach. First of all, it says that statements from accusers who then choose not to appear at hearings can't be credited at all. They have to submit to a fair process. Secondly, the regulations make clear that schools must evaluate both inculpatory and exculpatory evidence. And third, there was some evidence of training bias in the Purdue case. So where is the sort of the fundamental linkage between the regulations and these rulings? To me, where it's sort of the best articulation of this comes from what is, I think, still the most eloquent and understanding of any of the decisions in this area, a 2016 decision involving a case at Brandeis, which just had this bizarre set of facts. A long-term monogamous gay couple had a bad breakup. One of the accused student then, charges that his former boyfriend committed sexual misconduct against him by, among other things, looking at him in the nude in their communal bathroom without requesting his advance permission to do so, which would be a standard that would basically suggest that virtually any married couple in the country committed sexual misconduct at one point. And in the opinion, Judge F. Dennis Saylor of the District of Massachusetts said that the key problem in the aftermath of the Dear Colleague letter was that universities had substantially impaired, if not eliminated, an accused student's right to a fair and impartial process. It is not always enough simply to say that such changes are appropriate because victims of sexual assault have not always achieved justice in the past. Whether someone is a victim is a conclusion to be reached at the end of a fair process, not an assumption to be made at the beginning. Each case must be decided on its own merits according to its own facts. And to me, that's the underlying principle of the regulations, and it's the clearest linkage between the regulations intent and what we've seen from these campus litigation rulings. Thank you.
Thank you, Casey. That'll be a nice segue into a discussion regarding terminology, not just the word victim, but the word survivor, which appears in so many of these discussions regarding sexual misconduct. So we'll bookmark that. And let's turn now to Nicholas, Professor Wolfinger, to hear a little bit about how these campus proceedings unfurl on the ground from your personal experience. And then, of course, feel free to add comments about the regulations as you see fit.
Thank you very much, and thank you everyone for being here today. I'm a tenured professor at the University of Utah, where I've taught since 1998. I'm here today as one of the handful of people, one of only several faculty members who's endured a Title IX complaint and lived to tell the tale. Anyone who's interested in what I'm going to say should take a look at the pair of articles I've written in the webzine Quillette, where I first told my story in public. There's an annual date I always consider the worst day of the year. That's the date I take my 120-pound pot-bellied pig to the vet. I have to rent a U-Haul, go pick up day laborers at Home Depot, chase Samson into his crate and get the crate hoisted onto the U-Haul, then go drop off the day laborers and drive half an hour to the vet. After Samson gets his tusk trimmed and his hose ground down, I have to do the whole thing in reverse. In 2017, the day was already off to a bad start after I'd gotten a traffic ticket for having 3 people in the 2-person U-Haul cab. I was driving from the vet when I learned of the complaint against me and had my one and only phone conversation with the investigator. I had no idea that this was even a sexual misconduct complaint, only that the university staffer wanted to discuss, and I quote, an important and confidential OEO/AA matter. I had no idea what that meant. I didn't know what the OEO AA office was, or even though I surmised eventually that AA probably meant affirmative action. It was the Office of Equal Opportunity. Still, this told me nothing. The subsequent emails I exchanged right after being notified of the complaint read like this. Investigator, we need to meet to discuss something. Me, I'm out of state, so can we talk on the phone? And what's this regarding? Investigator, there's been a sex discrimination and harassment complaint against you, and we need to meet. Me, I'll call today. Meanwhile, please email me the complaint. Investigator, we typically don't provide written notice of the complaint without a meeting. Me, I have no intention of returning to the state of Utah for the foreseeable future. Please email me the complaint. I was telling the truth about being out of state. Since 2013, I've lived in Northern California and commuted to Salt Lake when I'm in the classroom. I chose to live out of state for just this sort of thing. I have a long and unhappy relationship with my department. I was nearly denied tenure, with the department actually voting against promoting me by a 2-to-1 margin. I subsequently was denied promotion to full professor the first time I went up. My pay was frozen for almost 10 years. All of this was for ad hominem reasons that had nothing to do with shortcomings in my research or teaching. By living out of state, I avoided contact with my colleagues and made it harder to be dragged into meetings like the Title IX investigator was now proposing. And common sense told me I would not go into a meeting like this without the ability to prepare for it and first speak to an attorney. At this point, I'd never heard of the 2011 Dear Colleague letter. Title IX was just about gender equity in higher education. I didn't know who Laura Kipnis was, so I hadn't read her account of being investigated. I hadn't come across any of the high-profile cases that had made the news, like the Brandeis student punished for watching his sleeping boyfriend and kissing his sleeping boyfriend. Instead, I figured that this complaint against me was simply my university discovering a new means of trying to harass me. They hadn't filed trumped up allegations of sexual impropriety up until now, so I figured they were finally giving this a shot. This impression was confirmed a day later when I received a 2-page summary of the charges against me. My initial reaction was best described as perplexed. Most of the charges concerned conversations I'd had with my colleagues in the late 1990s, soon after I joined the faculty at the University of Utah. Here is a representative example, and I quote, "You have recounted stories to female faculty members relating to your proposal to your wife and how you proposed at a strip club during a lap dance." This is true, except for the part about the lap dance. It's the only possible story I could tell about my marriage proposal. Indeed, I didn't even have a different marriage proposal story to tell. It was recalled to my 3 fellow assistant professors, all of whom were women, off campus over drinks and pizza at the Pie Pizzeria in Salt Lake City. Our conversations were often off color, as anyone who's ever had a drink with coworkers might relate to. It was probably also around this time that I used the euphemism, and I quote, "riding the cotton pony" to describe menstruation. This too was in the complaint. These two and several like it were erroneously alleged to have taken place between 2004 and 2016, when in fact they had taken place in the late 1990s. I don't know how these dates were chosen, that it's noteworthy that my accuser waited over 10 years to initiate a complaint against me. I was also accused of gender bias. The evidence? At one point in a faculty meeting, I'd shown support for the findings of an external review committee that had been critical of my department. This indirect criticism of my department was somehow construed as gender bias because my department head is a woman. And it didn't seem to matter that she'd been my closest friend in the department for years. So it makes me wonder, if my department head had been a man, would I have been accused of misandry? In, in any event, I somehow doubt whether the woman who filed the complaint truly knows how I feel about women. So the dossier the university prepared against me also contained allegations of an unnamed reporter who'd phoned my academic department to complain about something I'd said. What reporter? I've talked to hundreds of them in the course of my career, which is what happens when you study marriage and divorce. What had I said? I don't have a clue, although potty mouth is a good bet because it often is with me. I don't know the answers to these questions, and I never will. Indeed, I don't know if I'd even talk to the reporter in question, or for that matter, whether she's really a reporter. All I know is that someone contacted my department to complain about me, and the university saw fit to introduce this evidence into official proceedings. It's hard to imagine anything having a more chilling effect on scholarly life than the prospect that anyone can contact your university to complain about anything at any time. And hey, if any of you are still mad about a bad grade you got in college, here's your chance to get even. Uh, the summary of allegations I received from the university's Title IX enforcer instructed me to respond in writing within 2 days, although I received no indication about how I was supposed to respond. Well past 2 days later, I informed the investigator that I needed more time to consult with my attorney about my response. At this point, which was the first time I mentioned that I'd lawyered up, his tone softened markedly and I was told to take all the time I needed. My investigation dragged on for 4 months. It was to my advantage that I was able to conclude my investigation without ever having an in-person meeting with my investigator. Indeed, I never even spoke with him on the phone again after I first received the written complaint. Although, after I provided him with my written rebuttal of the charges, the investigator proceeded to interview 12 of my colleagues. My 2 other colleagues failed to respond, and a number of graduate students were contacted. None of them responded either. At the end of the investigation, I was found not responsible for sexual misconduct, but I wasn't out of the woods yet. Although it was totally irrelevant to the allegations against me, the investigator's final report went to some length to depict me as a lousy colleague. I rolled my eyes in faculty meetings. I said fuck once, and so on. It was clear the investigator was trying to gin up source material for another complaint, which would originate somewhere else in the university. I asked the investigator to remove this content from the report, citing its irrelevance to the original allegations against me. I pointed out that I collaborated with 4 different departmental colleagues on a variety of publications, including an edited book, so I couldn't be too terrible a colleague, but this was to no avail. 2 months later, the new complaint, indeed about my collegiality, arrived from my dean. It cited the eye-rolling one-time profanity and my, and I quote, hostile body language in faculty meetings. For these transgressions, the dean had imposed 2 penalties. The first was an official reprimand with a promise that I'd be fired if my body language didn't improve right away. The second was the loss of a month's pay, which was more serious. Think about that for a minute. Have you ever heard of a faculty member being fined thousands of dollars for anything, let alone hostile body language at a Research One university? I certainly hadn't, nor had any of my friends in the profession. The pro forma portion of my dean's letter informed me that I was entitled to have this punishment reviewed by a jury of my peers, convened in something called the Consolidated Hearing Committee. So I contacted the responsible administrative assistant, fairly certain that a bunch of faculty members wouldn't be inclined to set the precedent of fining a faculty member for comportment. I asked the assistant for the protocol for hearings. Any indication of what hearings in the past have been like, that sort of thing. I was surprised to learn that not only could she not tell me about this protocol, but she couldn't recall that any such hearings had ever been held at the University of Utah. Maybe she was ignorant of hearings in the past, but still her answer was striking. I didn't relish the prospect. It was a trial, and a trial would be expensive. My attorney was still on retainer at the time, and it would be time consuming. Would I be allowed witnesses? Could I cross-examine? No answers were forthcoming. So finally it came as a considerable relief when the vice president for faculty, who outranks the dean in the academic food chain, realized that the dean's attempts to find me were utterly nuts and made the whole thing go away, and no third investigation was forthcoming. I've since written several articles about my experience, including an op-ed in the local paper. My university wisely never said a word. Ultimately, I was lucky. Many faculty careers have been ruined by complaints like the ones I faced, and many students have been expelled from college and unable to matriculate elsewhere. My costs were limited to the 6 months I wasted writing response memos at about $14,000 in attorney's fees. Let me end by adding that I support the broader aims of Title IX with respect to gender equity in higher education. My 2013 book, Do Babies Matter? Gender and Family in the Ivory Tower, addressed the barriers that female professors face and proposed institutional reforms to level the playing field by making scientific careers equally available to both sexes. I'm proud to say that this research led to major changes in how the 10 campus University of California system goes about recruiting and retaining faculty. But that's a world away from trying to find a faculty member for slouching in a meeting or punishing him for talking about his wedding proposal. Thank you.
Okay, thank you, Nicholas. I'm going to exercise the moderator privilege and start with a few questions that I've had, and hopefully they can clarify for others. It still seems somewhat confusing how a ban on sex discrimination can result in these types of investigations of off-color comments. So Samantha, I'm wondering if you could speak to the concept of educational access and how that is supposed to cabin in a ban on discrimination and sort of be the touchstone for what conduct constitutes prohibited Title IX conduct. Access.
Yeah, so, and this is something that the new regulations address, because we've been talking here a lot about the concept of the due process aspects of the regulations, but there's actually a huge free speech piece here too, which is that one of the other things the regulations do is define sexual harassment in a way that is consistent with the Supreme Court's decision in Davis v. Monroe County Board of Education, which is the case that originally held that there's a private right of action for students under Title IX, but it also defines sexual harassment quite narrowly to avoid infringement on free speech. And the definition in Davis is conduct that, punishable or actionable harassment is conduct so severe, pervasive, and objectively offensive that it effectively denies the victim's access or benefit, access to an educational opportunity or benefit, excuse me. It's a mouthful. But in recent years, the Department of Education had been using a much broader definition under the Obama administration in a number of resolution agreements with individual universities, including one at the University of New Mexico that the department referred to as a blueprint for colleges and universities nationwide. The department defined it as any unwelcome conduct of a sexual nature, which is extremely broad and really opens the door for schools to investigate students and faculty. I mean, if anything, these sexual harassment, these verbal sexual harassment investigations have hit faculty especially hard, and right in the context of classroom speech, which I think is one of the greatest dangers of this. Right now, any faculty who teach sensitive topics are at great risk of harassment accusations just based on what they discuss in the classroom. And so, the new regulations, the narrower Davis definition that's focused on conduct that's severe, pervasive, and objectively offensive and actually limits equal access to educational opportunities is much narrower. Now, the department did make clear in the comments to the regulations that the question is not access, but rather equal access, because one of the things that commenters expressed concern about was, well, does this language mean, for example, that a student has to drop out of school before the harassment is actionable? Do they actually have to be denied access? And the department said, no, they have to be denied equal access. And that's something short of access altogether. So it does allow the university to take some kind of action before things get so bad that a student is completely, effectively denied access to their education. The focus is on equal access, but you do have this much narrower definition of harassment that hopefully limits the free speech implications of these regulations and of Title IX.
So would it be fair to say that in Nicholas's case, for example, under the new regulations, it would have had to be made explicit that the complainants had somehow lost equal access to educational opportunities and benefits? That's sort of understood as part of a Title IX complaint.
Yes, it would have to be shown, first of all, that, the conduct was not only offensive to the complainants, but also would be offensive to a reasonable person in the complainant's position, right? So subjective offense is not sufficient to create a claim of sexual harassment. Generally speaking, it would have to be repeated, right? Under the new regulations, it's going to be very difficult to show that a single comment, an isolated comment, rose to the level of sexual harassment, because for most reasonable people, an isolated comment is not going to stop someone from coming to class. Really, you're going to be looking at this question of, is the atmosphere sort of permeated by sexual harassment? And it's a higher standard.
Right. Now, just to clarify, there is also what's called the quid pro quo proposition, where a superior would demand sex in exchange for grades or admissions or scholarships. And that, I think, is deemed inherently discriminatory without any question to access. I think the category we're discussing now is what's called a hostile environment. Is that correct, Samantha?
Correct. We're talking about hostile environment harassment, quid pro quo harassment, which, mind you, schools can also screw up. I have a case right now where the school screwed that up royally, but that doesn't tend to implicate free speech in the way that hostile environment does.
Right.
A quid pro quo investigation is still vulnerable to all of the same due process failures that, for example, a physical sexual misconduct investigation might be. But when we're talking about the impact of the regulations on free speech and on professors' academic freedom rights in the classroom, it's really that hostile environment standard that we're looking at.
Okay, great. Thank you. Now, Casey, I don't know if you can field this question, but one obvious issue, especially given Samantha's introductory remarks about the relationship between the criminal justice system and the parallel justice system that's taking place on campus. Are you aware of any interplay between criminal investigations or the role that prosecutors or criminal defense attorneys play with what's happening on campus with Title IX?
Yeah, this I think is one of the most troubling small changes, or maybe lesser noticed changes from the Obama years. During the Bush administration, OCR had issued a resolution letter. They didn't have guidance on this, but in a resolution letter with SUNY Buffalo, they had said that in cases where there was a parallel criminal investigation, it was okay for the school to defer its Title IX investigation until that criminal investigation concluded. And the argument that OCR made in this resolution letter, which I think is correct, is that if this didn't happen, the accused student would be faced in this, terrible position of having to either participate in the Title IX process or invoke his right against self-incrimination and maybe have that evidence used against him. Since 2011, that restriction has been gone. OCR under Obama, and actually still under DeVos, has said that schools have to move forward with with both cases in parallel. And I think there are a couple of real problems with this. The first is that even though Title IX proceedings are shielded by FERPA, they're not necessarily shielded by a subpoena. And so a prosecutor can subpoena these Title IX proceedings and potentially could use them in a criminal proceeding. Although that's not something that I've seen any case happen so far. What has happened is the reverse, a case where, say, the accuser chooses to file parallel criminal and civil charges. And one that comes to mind, which is a case that we're waiting for the final decision now any day from the Eighth Circuit, was a case at the University of Arkansas. Accuser went both to the police and to the Title IX office. The student correctly hired a criminal defense lawyer. Criminal defense lawyer correctly told him, you can't speak to the Title IX coordinator because this may cause problems down the road criminally. Turns out this student was innocent, and the police dropped the charges almost immediately. But this issue for an accused student, if you are faced with this situation, and your lawyer tells you don't testify in one of these Title IX proceedings, you can't. There is a provision of the regulations that says that Title IX panels cannot hold the silence of an accused student against them in making that decision. And that's all well and good. It says that on paper, but in the real world, we know that if you have a Title IX process where the accused student does not testify, he's going to be found guilty. I mean, that's just the way the process works.
Mm-hmm. I'm wondering also if you might be familiar, Casey, with a law review article by Catherine Silva, which addresses the problem from a feminist point of view that certain cases of sexual misconduct were not being prosecuted because of evidentiary obstacles, and that Title IX would be a way, at least for the campus scene, to compensate for those cases that didn't meet the prosecutorial threshold, but they would get sort of a second bite at the apple on campus. Are you familiar with that?
Yeah, I mean, that's a fairly common argument. And the problem with that line of argument was best addressed in a decision that I think is one of both Sam and my favorite decisions. It was this district court decision in a lawsuit against Notre Dame. And this was a terrible case. Notre Dame had ignored exculpatory evidence. The guy was clearly not guilty. And Notre Dame's argument was that as schools usually argue in these cases, is that this was an educational process. It was not a punitive process, and therefore they didn't have to treat this guy fairly. And the court said no. That if you're going to kick a student out, if you're going to take his money, if you're going to brand him a sex criminal for the rest of his life, it's a punitive process. And so to the extent the argument is made, and this, you see this a lot from defenders of the current Title IX process, that it's too tough to prove these cases in court, that prosecutors don't want to take them, so we should take them into the campus proceeding. But the problem is that the fiction of the Title IX process is that it's supposed to be educational and not punitive. And so if you're going to say the purpose of this is to get justice for the accuser, then you have to give the accused student substantial rights. You can't have it both ways.
Can I jump in and add something else here?
Sure.
Which, I think this goes back to what I was saying about sort of the changing norms on campus. One of the other problems is that, campus codes they define sexual misconduct much more broadly than it's defined at law. And a lot of what is, adjudicated in these campus tribunals is in fact lawful conduct. And one of the big problems is the terminology doesn't distinguish that, right? So, in the old days, you had schools with parietal rules where sex was prohibited, right? And you could be kicked out for having sex. But if you weren't branded a sex offender for life, right? You just violated some sort of internal college rule. To some extent, if colleges, particularly private colleges, want to radically redefine what it means to consent to sex and engage in some sort of social experiment, right? They, to some degree, have the right to do so. But what I think is really problematic, look, I think that's problematic for other reasons, but, in terms of schools' rights, they could do that, right? They can engage in that kind of social experiment just as, the schools in the 1900s could ban sex. But by adopting the terminology of the criminal law and calling it sexual assault and finding that, if you ask a female student one too many times for sex and she says yes because she's tired and wants to go home, that you are now guilty of sexual assault, and that's going to follow you on every educational record, job application, and so on and so forth for the rest of your life. That, I think, is one of the real fundamental problems here. So, in addition to the fact that a lot of these campus cases simply aren't prosecutable because of a lack of evidence, a lot of them simply don't rise to the level of crime. And yet colleges are effectively calling them crimes. And calling them crimes on students' educational records. And I think that is really kind of a huge piece of this that, isn't talked about that much.
If I could probe a little bit more on that point, Samantha, even apart from the terminology, if schools are free to prohibit conduct that is much more broadly defined than, for example, the Davis standard, are they then free to use the Title IX office to investigate and adjudicate that conduct? Because to my mind, yes, a school is free to prohibit blowing a kiss, holding hands. I mean, they are free to do that within the realm of their student conduct code.
Right.
But what is going to trigger a Title IX violation and then a Title IX investigation and adjudication? Doesn't that conduct have to be the Davis standard?
Yes. So under the new regulations, it will, and maybe that will actually, go a ways towards resolving this issue, because no longer will schools be able to call it sort of, it won't fall under the auspices of their sexual misconduct policy that's administered by the Title IX office. No, I'm not encouraging schools to go out and adopt restrictive sex rules, but I'm just sort of pointing out this phenomenon that, that adopting restrictive sex rules is particularly problematic when you call violations of those rules sexual assault. I mean, I think students are adults and that schools should not be acting in loco parentis and trying to radically redefine, what it means to consent to sex, but that's sort of a separate issue and that's a different debate. But in terms of this debate about sexual misconduct, I think it is clear at a minimum that if they are going to do that, they should not be calling it sexual assault.
But I do think that under the rules, at least there are 6 states that define sexual assault under state law differently on campus than they do in the criminal statute. And in those 6 states, I do think that the regulations don't have a definition of consent. They allow schools to choose their own definition of consent, and they do say that sexual assault cases can be adjudicated under Title IX. So in those states, California, Colorado, Illinois, Minnesota, New York, and Connecticut, I think we'll still see these non-criminal cases that the states call sexual assault because they just involve college students continue to be adjudicated through Title IX.
So can I ask a question of Samantha and Casey? The reaction of many colleges to the new guidelines are, the system we have is working fine and we don't like the Trump administration too much anyhow, and you're part of it, we're just going to stick with the old rules. Is it going to take a lawsuit to bring the new guidelines into effect?
Well,
I think,
go ahead, Casey.
I mean, I think that's, I mean, obviously there are going to be lawsuits to challenge the regulations, but from what I've seen in terms of responses from school Title IX offices, and I sort of try to follow the campus newspapers every day, and I've been maybe 30 or 40 that have issued statements. They've all said basically the same thing. We don't like these regulations, but we plan to implement them. So there isn't, the question is how fairly they'll implement them, but there haven't been any schools so far that have simply said, come August 15th, we're just going to pretend that these regulations don't exist and we're not going to implement them.
Right, and I think it's going to take, it's going to take fending off several lawsuits to implement them, but that's a different story.
Right. Thank you.
So I have one question here that wants the relationship between offices on campus called affirmative action, equity and inclusion, and Title IX offices. How do they collaborate? But I might also add that it's my understanding of the regulations that a Title IX office can on its own initiate a Title IX investigation. And I'm going to throw that out for comment because I think one due process red flag is, for example, when an accuser does not show up and the entire show is being driven by the Title IX office. So I don't know who would like to address that.
I'm not quite sure I understand the question.
Well, so ordinarily in an investigation, there would be an accuser who would file a formal complaint. But is it possible under the regulations, I think it is, that a Title IX office itself without an accuser can instigate a Title IX investigation and adjudication?
Well, yes, and I don't think that on its, and others can feel free to disagree with me, I don't see a problem with that on its face, in the sense that I think if you had a case, right, say you had a case where a student was violently raped, right, by another student on campus, and that student, the victim did not want to come forward with an investigation.
I have lost Samantha.
All right. Well, I'll chime in because I think there's a case like that was a Fifth Circuit case, and that was a case where a student who was incapacitated had been assaulted, and the two people who assaulted her took videos and pictures of the assault, and the accuser didn't necessarily want to go forward because she had no memory of the assault, but this evidence found its way to the Title IX office, and I think under those circumstances, there's nothing inherently wrong with the Title IX office saying, look, I have independent, uncontrovertible evidence that we have violent rapists on our campus. We're going to get rid of them. Where it comes into problem, and this was the most famous of these cases, was a case involving Jack Montague, who was the former basketball captain at Yale. And Yale was under pressure from accusers' rights groups, from campus protesters, that they weren't cracking down enough on sexual assault. The Title IX office found out that there was a woman who had had a bad experience. That's how she described it with Montague, but she didn't want to file charges. And the Title IX office basically rigged the procedures to file the charges themselves, found him guilty, and expelled him in the middle of the season. And that, I think, under the regulations, there are lots of things with the Montague case that were inappropriate, but that wouldn't be allowed. But the idea of a Title IX office who has independent evidence of guilt, an accuser who doesn't want to testify, that seems okay.
Okay, so you're raising another issue which has to do with timing, which I think Nicholas's story also touched upon. The regulations, as far as I know, do not have anything comparable to a statute of limitations, which is to say a deadline by which a complaint must be filed, which you have, of course, in both in the civil and criminal justice system. And one side issue of that is the risk of vindictive complaints, that is something being filed on the eve of the big game or filed before graduation, so that an accused, those events are jeopardized for the accused. Do you want to speak to that, Casey?
Yeah, this is a really difficult issue. So that first quote that I gave from the Beermeester ruling today, where I said that the court was basically saying what we have is a principle of balancing the rights of the victim for safety with the rights of the accused. And here, basically every college, pushed by the Obama administration and allowed by these new regulations, have said that yes, there's a tension between these two principles, but we're going to err on the side of reporting rather than rights of the accused, and in this case, not impose a statute of limitations. We've all seen the problems with this, where you have allegations. There's this case now that's going through the courts involving Harvard University, where the allegations were filed against the guy like 2 weeks before graduation, and he was denied his diploma. But I think that the department's argument here, and I largely agree with it, is that if you provide fairness to the accused student in other aspects of the process, that it's okay not to impose a statute of limitations here. Again, when we're dealing with students, there's an inherent statute of limitations, because once they're off campus, the process is over anyway.
Yeah. Okay, just to circle back to the question that was posed on the chat, my experience with these equity inclusion offices and affirmative action offices, and I would add student health centers, is that
can you hear me? I'm so sorry. We lost power in my neighborhood. There was apparently a fire on an electrical pole down the street, and the power company came to fix it and cut the power. So I've now rejoined from my phone. I apologize for dropping off in the middle of answering a question.
Oh, okay. I don't remember. What were you responding at the time? Do you want to?
Yes, I was responding to what was the question? But if you've moved on, just
Samantha, it wouldn't be a Zoom session without a story like that. So
do you remember the question I was answering?
Well, I brought up Title IX offices on their own being able to initiate
Yes,
investigation.
Right. So I think that they have to be able to, because I think that if they're aware of a danger to students, right? If somebody's violently raped by a fellow student and then that student refuses to come forward, the college would obviously be remiss if it did not take action to protect the rest of its student body. And that is one of its obligations under Title IX. I think that under the new regulations, the clear separation of powers, I mean, obviously you can't have the person who brings the case and is acting as the complainant also be the person responsible, the same office responsible for adjudicating the complaint. So I think particularly when the complaint is initiated by the university, that separation of powers in the regs is especially critical. But I do think that a school has to, for the reasons I just said, I think a school does have to be able to initiate a complaint under certain circumstances.
Yes, I think I would be more comfortable if those standards and metrics were made clear by the regulations. I confess that a lot of discretion with the Title IX office makes me a little nervous because of the many cases where it appears the discretion has been abused. So I noted that, and I would say by the same token, the very same thing applies with the provision of emergency removal. I would prefer to see more standards and metrics that emergency removal can really only happen with a certain set of conditions showing that the student is a true danger to the safety of the remaining people on campus. Because let's remember that the accused student also has a Title IX right to equal access to education. And there's a risk of jeopardizing that access if you have a too speedy process that doesn't have standards spelled out in advance is one thing that I think should be kept in mind. I was in the middle of explaining that a number of offices on campus are typically involved in different capacities with allegations of sexual misconduct, from the Equity and Inclusion Office, from the Affirmative Action Office, and also student health centers and wellness centers. So there is a certain amount of collaboration and cultural overlap with these entities, but as far as specific Title IX complaints and investigations and adjudications go, as far as I understand it, that falls squarely with the Title IX staff members. So there was another comment on the chat that wanted it raised that many of these complaints disproportionately affect minority students. Does anyone want to address that?
I'd be happy to address that because it's true. And, one of my very first cases in private practice was a student who was a student of color, a first generation, his mother was an immigrant. It was friends and family who paid for the defense, and the accuser was white. And it was very much, it's been very interesting to see that a lot of people who otherwise are very concerned about issues of racial bias and things like that seem to have a blind spot when it comes to these campus adjudications. And there are a number of people, Janet Halley from Harvard is one of them, who have written a lot about this phenomenon and about, some of the biases. And I think Casey can probably speak to this too, just that we see, I haven't run the numbers, but just looking at the lawsuits that we read, it does seem like a disproportionate number of them are, brought either by minority students or international students. Casey, what do you think about that?
Yeah, I think that the interesting split here is that you see, again, the significant, and I would agree with Sam, disproportionate number of cases with white accusers and accused who are basically men of color, and very few cases with the reverse. You don't see lots of cases with say, black accusers and white males of color. And so there is this issue of, it's the sort of thing that in any other capacity would concern liberals. And the New York Times, which has basically ignored the due process issue in this area entirely, their one intervention in this came in what was a wonderful op-ed from Laura Bazelon, who was practiced in this area out in California, talking about her experiences representing accused students of color facing, you know, these unfair processes. And so I think virtually anyone who is sort of practiced in this area has stories where it seems like students of color are the ones who are targeted here. And yet, you know, the NAACP has been silent on this issue. Groups that the ACLU really has never concerned itself with the racial discrimination thing. It's a puzzling oversight.
Yeah, so thank you. That warrants attention. I'm going to throw out two last things for comment, in part because the chat has recommended that we pick up on the question of terminology. I have been so struck with the unquestioning use of the term survivor and victim, and I'm reminded of the Casey Johnson's quote from, I think it was a trial court in Massachusetts, that pointed out that these terms are conclusive and really should only be used after a proceeding with due process protections has determined responsibility. So I throw that out for discussion, but also I'm hoping we can at least touch on the question of prevention, because this is a miserable experience for all involved. And while it is commendable that we are paying attention to due process protections, I'm sure that most anyone involved in these investigations, with the exception perhaps of the most ideological, would prefer not to have this type of experience at all. And there's a part of me that thinks in making healthy relationships such a minefield, no guidance on how to navigate this difficult terrain of dating and relationships, it's sort of falling into this legalistic, as I say, minefield where a lot of people get hurt. Complainants, the accused, families, everyone. But I'll just throw that out there if you want to comment on the terminology or the lack of prevention.
Yeah, I mean, one thing I'll say as a woman and as the mother of daughters is I'm troubled, you know, as much as, you know, we focus a lot, and rightly so, on the harm to accused students. I actually think that the sort of pathologizing of so much of this and the hello, sorry, the power just came back on, so there was a little interruption there. But I think that the pathologizing of this and the use of sort of all of this trauma terminology to refer to a lot of things that, you know, for women who grew up in previous years and who attended college in previous years, you know, may have been sort of choices they might, particularly when it comes to things like, you know, alcohol and sex, you know, I feel like we are turning sort of a generation of college students both into sex offenders, but also into trauma victims. And I honestly don't think, I really question whether, you know, these female students who are being told by people in positions of authority, people who they look to, that they've suffered trauma. You know, if they go and they say, gosh, you know, last night was rough, I had too much to drink, I woke, you know, I don't really remember what happened. And suddenly they're, you know, being told that they've suffered a terrible trauma. I sort of question, and I guess only time will tell, but I question what the long-term psychological impact of that.
Yeah. I lost Samantha.
Yeah, I would echo Sam's point on sort of this issue of effect. It's one reason why I don't really like using the word false allegation in this context, at least most of the time. Some of the allegations are clearly false, but a lot of times you'll have allegations that are presented in good faith, but they simply don't rise to the level of sexual assault because you have a campus environment where students are told, you know, if you had a bad experience, it probably was rape. On this issue of terminology, one of the things that I think the regulations does best and hasn't gotten anywhere near enough credit for is that it basically tells colleges it's perfectly fine to presume that a campus complainant is a survivor if in the realm of supportive services. If she, if she comes to the Title IX office and says, I need a class accommodation, I need a room accommodation, I need mental health accommodations, I'm not
Yeah.
going to adjudicate this. And the regulations are clear to the colleges. You have to help in these circumstances. It only is when you begin a disciplinary process by presuming that the complainant is a survivor that it's inherently unfair, because once you start with that as your starting point, the accused student's only defense is to prove that someone else committed the crime, because
Yeah.
you know, if we've already, so it is an issue. On the question of prevention, you know, there's this yawning gap between college administrators who to a person maintain that 1 in 5 of their female undergraduates will be sexually assaulted while on their campuses, which would be, you know, somewhere around 400,000 female undergraduates a year, and yet don't seem to be doing anything, or seem to be doing very little with regards to the question of prevention, which raises a question of whether these administrators really believe these numbers. This was a point that Sam addressed in a co-authored piece last week with Reason, where she pointed out that, look, you know, what we've seen over the last 2 months is how a college really responds to an epidemic, when we've seen schools shut down as a response to the virus. But, you know, certainly administrators who believe the 1 in 5 figure and don't spend all of the time that they can on prevention issues should be called out every day of the week for hypocrisy, because there's just no other explanation for it.
Yeah. Okay. Well, by my clock, we have 3:20. So I think that we've covered most of the bases, and it's probably a reasonable time to conclude. So thanks to all who have listened and posted comments and questions. And thank you, of course, to all the panelists. This is a conversation that will continue as the regulations take effect, as complaints against the regulations are filed. Just a note, there was actually one complaint already filed in federal district court in Maryland by the ACLU on behalf of Know Your Nine and other like groups. So there's going to be more activity. There's going to be more discussion. Hopefully that discussion will be better informed because of this event. So thanks to all the panelists. Thank you, Chance, for the technical assistance, and we will all be in touch. Okay?
Thank you, and sorry for the
Thank you.
technical difficulties. I hope it wasn't too disruptive for anyone.
It makes it complete. The Zoom meeting complete.
It's
Okay.
not a coronavirus event without it.
Exactly. Okay. Farewell.
Thank you.